Good evening, and welcome to Rescuing the Rule of Law, a series of shows exploring major threats to our 250-year-old American system of equal justice and due process for all. It is this rule of law, with its checks and balances, that protects the rights and freedoms of the people and stops us from falling into a dictatorship. The rule of law is the idea that our laws, our rules, should apply the same to each and every person, no matter whether you are rich or poor, have friends in high places or not, and no matter the color of your skin or your religion. Hello, I'm Roger Cates, a former state senator and Augusta attorney. The show is produced by Maine Lawyers for the Rule of Law, a group representing hundreds of Maine lawyers devoted to defending the rule of law built into our federal and state constitutions. This group helps educate the public about the essential role of the rule of law in keeping our democracy alive and the need for everyone to stand up for it. You can learn more about the group on its website, mainruleoflaw.org. In this second show in our series, we'll look at a recent case that pitted the state of Maine against the Federal Department of Agriculture. In this case, Maine's Attorney General invoked the rule of law to prevent the abrupt and unwarranted withdrawal of federal financial support for school lunches here in Maine. We'll see how a U.S. District Court applied the rule of law to protect Maine's school children from arbitrary federal action. This is an example of the rule of law at work right here in the state of Maine. I'm pleased to introduce our panel. Aaron Fry, Attorney General of Maine, Melissa Huey, longtime civil litigation attorney in Portland, and Peter Murray, law professor, lawyer, and member of the board of directors of Maine Lawyers for the Rule of Law. Let's begin. So, Melissa Huey, tell us how we got to this place. How did this case start?
So I think in order to understand what happened here, it's really important to start with the timeline. And that started on January 2025, when the president was sworn into office. I think everybody knows that he issued a slew of executive orders, one of which was defending women from gender ideology extremism and restoring biological truth in the federal government. And basically what he said in that executive order is that it's the policy of the United States to recognize two sexes, male and female. These sexes are not changeable and are grounded in fundamental and incontrovertible reality. So that was number one. And then we move about 2 weeks later to February 5, where he issued another executive order to sort of shore that up. This one called Keeping Men Out of Women's Sports. And in that executive order, what he said was essentially that transgender female athletes should not be permitted to play on female teams. So let me step out of the timeline for a minute and say that the president's construction of Title IX is different than most attorneys, most courts, most legal scholars had at the time, and there was no federal guidance that supported what he was saying. So that's the first thing that's important. The second thing that's important is that a number of states, including the state of Maine, have laws that very clearly require schools to allow transgender students to participate in school activities and use school facilities that are consistent with their gender identity. All the governors and the president gets together for lunch, and that's when, I think we all know, there was an interchange between Governor Mills and President Trump. He asked her if she was going to comply with federal law. She said, I comply with state and federal law. He said, well, I'm federal law. And she said, the now famous, on a lot of sweatshirts, phrase, see you in court. So that was around noon on February 20th. And by the afternoon of February 20th, the Office of Civil Rights had issued complaint investigation letters to the state and to SAD 51, which is a school district that had a recent win for a transgender female student. Those complaint investigations usually take months to go through, sometimes years. In this case, we were given 1 week to comply with what they were asking for, and within a couple of weeks, the investigation was finished. There was a determination that the state and the school had violated Title IX, and both state and school were given voluntary resolution agreements that they could agree to, otherwise they would be sued. So state, the school district, respectfully said no, and interestingly, that was it. We've heard nothing since then.
And by the way, the issue of whether transgender athletes should be allowed to participate in sports in schools, Maine law says yes. At the present time, the federal executive order said no. So there's a conflict between those two.
But it's important to draw a distinction between what the executive order says, which isn't the law, and what the law is. And the law is really in flux, and we may talk about that later. But right now, we know what Maine law says. And the governor, and I think the state, decided that they needed to follow what the Maine law said.
Right.
So that's when there was this pivot. And suddenly the Office of Civil Rights is out of the picture, and the Department of Agriculture is in the picture. And then that's when there was a threat to remove federal funding that would impact negatively on school lunches.
One of the things the Federal Department of Agriculture does is manage those programs which support school lunches throughout the country.
Yes, but one of the things the Department of Agriculture does not do is have anything to do with sports.
Right.
So it was kind of out of left field, and that's when we had to turn it over to our Attorney General, who had to act very, very quickly.
Okay, so we're now in the timeline up until to when roughly?
The letter was on April 2nd, is when we got the letter from the United States Department of Agriculture, USDA, indicating that they were shutting off funding to that program.
And the department is saying, you all are violating federal law. You're not going to get any more money for school lunches.
Right, and I think it's important to understand that if they had followed through with the litigation, that's a lengthy process. It doesn't really affect anyone, and I think that might be the reason for the pivot.
Let me first highlight that the impact of this cut from the USDA, it would have affected about 170,000 school children having access to this nutritious food. And we don't talk about this as much. It was also for vulnerable adults. We're also going to lose access to a program that helped provide them with nutrition. So without engaging in any process, without engaging in any legal analysis or making any legal argument, the Secretary of USDA, Brooke Rollins, had said, we're just going to cut off your funds. And so when it came to us, we do what we do when a program that the state depends upon is threatened or is imposed upon. We look at whether or not the state has some legal interest that we're able to deal with, because we're the state's lawyer, right? And so when we're looking at something, we are advising our client, in this case the Department of Education and the governor's office, on what choices they might have, on what this would mean, on whether or not the Department of Agriculture has any legal basis for what it is that they were doing. Jumping ahead, they did not. The USDA did not have any legal basis for shutting off a program that fed school children and disabled adults. And so we worked with our client to figure out what our options were, which were we could just accept the cut and do nothing, and that means school children would not have food. We could agree to be bullied by the administration into what it was that they were trying to make us do, which was to reject Maine law, Maine human rights law, to reject our longstanding understanding of how Title IX worked and just accept what the president wanted us to do. Or we could go to court and which is what our country and our Constitution provide for. If we are concerned about whether or not our rights are being followed, that somebody operating with the power of government is not acting appropriately, we can go to court and have that sorted out. We obviously chose to go to court and have the judicial branch engage in whether or not the process that was not followed by USDA was appropriate when they made the determination to shut off funds.
So one of the choices you mentioned, which you chose not to pursue, was what the one the administration wanted you to do, I guess, which is to say, okay, we'll back off, we'll change our policy on transgender sports involvement, give us the school lunch money back. And that was clearly a choice to give into that. Who made the decision not to do that?
So ultimately, the decision to file on behalf of the state of Maine was my decision as Attorney General, right? Because that's what the Constitution and our laws provide for who makes the decision about how to deal with the legal affairs of the state, right? But that was not a decision made in a vacuum. That was a decision that was made in consultation with the Department of Education, that was made in consultation with the governor's office, and after reviewing what the state of the law provided for what was appropriate here. And let me add something else to this, right? Because even though the letter that was sent by the USDA, it didn't say anything about the exchange where the president was trying to bully the governor into his view on what the law was. That's the backdrop. So the backdrop of this is the USDA sending a letter that you would not expect a cabinet secretary to sign off on, right? It was a very blunt, sort of a gangster type letter of you better do this or else, holding back money for food for children to try to get the governor in the state of Maine to take a different course. You know, you really can't give in to that kind of bullying, particularly when the law is on your side, because if you give a mouse a cookie, they're going to want a glass of milk. And so if they're willing to use school children's access to food as a way in which to ignore the rule of law, to try to get you to agree to ignore the rule of law, that just wasn't an option. Long answer to your question, it was ultimately my decision to bring that case.
Right, and this had been money which had been appropriated by the Congress.
Correct.
Right? Which is their role in our system of government, appropriate the money. The executive branch carries out the actions that Congress approves and the spending Congress approves. There are times, though, when the executive could legally stop or attempt to stop funding, but not under circumstances like this.
That's correct. I mean, so what was very clear from the beginning here is that the USDA engaged in no process. Melissa was talking a little bit about this, how it developed up to the point of the state receiving a letter on April 2nd. There was no process that the USDA engaged in to make its determination that cutting off funding is appropriate. So yes, Congress does make that decision as to what programs are to be established, what money is to go to these programs. There's some limited discretion when it comes to the enforcement of these programs, but there is a process that an agency has to follow because in our country, the rule of law applies to everyone, right? The Constitution is a contract between people and the government. The government has limitations. It has to follow those limitations. The government, in this case, the Trump administration, because they were so fixated on trying to get Governor Mills to capitulate, right? On trying to get the state of Maine to capitulate, that they just blew through any process, I don't even think they looked at a law book on their way to sending this letter to the state of Maine. There's just no process followed.
So you decided to do what?
So we decided to file suit in the federal district court here in Maine. So with the federal government being being the defendant, right, with the USDA being the defendant, we have to go to federal court in order to work out what the rights are and what the rights aren't, right? Because we're asking the court to solve this dispute. And so we filed a case in the federal district court here in Maine.
Okay. And the basis of your suit, Aaron, was twofold, as I understand it. You said this is wrong for two basic reasons.
Well, really, there was only one claim that we alleged, and that one claim was there is the APA, the Administrative Procedures Act. This is the act that says, hey, government, this is the process that you need to follow in order to do what it is that you did here. And we allege that they just blew right through that and didn't follow it. Now, we did make sure to provide in our complaint information, that backdrop that I've referred to a couple of times about how this really, even though it wasn't on the face of the letter from the USDA, this was really about retribution. And so we made sure the court was aware that that was in the background, but the claim, what we filed for relief on is that the Administrative Procedures Act, the thing that the USDA would have to follow in order to do what it is that they did, that they didn't do anything.
And very quickly, what was that process? What if they wanted to cut off Maine's funding? What was the process they would have to go through?
Well, the USDA would have had to provide notice that there was a concern that we were doing something wrong, that they were investigating it. They'd have to come to some conclusion that what Maine was doing was inconsistent with what the program terms were, as Melissa had identified, USDA is not really in the business of enforcing Title IX, so it would have been curious as to how they would have done that, but they would have had to go through a transparent process to come to their conclusion. And they didn't do that.
And they didn't do it.
And they still haven't, by the way, but they didn't do that.
Right. So you sought a temporary restraining order. People think of courts and how long it takes to get anything done in courts. That's not always true. Tell us about your motion for a temporary restraining order and what that is.
Yeah, right. So when we filed, cases do take months, year, longer, and we had an immediate harm. And so you can go to court and ask for an emergency order, right? Emergency relief, which is the TRO that you described, the temporary restraining order. We alleged to the court that we had this immediate harm, that we believed that we, could show that we were going to win on the law when this case came to fruition, and that it was equitable for the court to enter an emergency order at the front end.
Fair.
Fair, yeah, that's right. That when balancing out what the federal government was doing and what the state was being harmed by, that it would be fair for the court to enter relief. And we asked that the court order the USDA to turn that money back on so that while the case pended, we'd still have the benefit of the program. So we made that offer and put it before the judge.
And you
short time frame,
very short time, a week or less.
Yeah. So April 2nd, we get the letter. We work with the governor. We work with the Department of Education here in Maine. My team, great team, they worked day and night to file on April 7th. So over the course of 5 days, they reviewed the case, they worked with the governor and the DOE, they got all the information they needed to file their complaint, and they worked to get all the evidence marshaled to ask for a temporary restraining order.
Okay. So as you say, then the case goes to a United States District Court judge here in Maine, and that's U.S. Judge John Woodcock. Peter, let me ask you to take it from there. What happened?
Well, the case was assigned, as you said, to Judge John Woodcock. Judge Woodcock is a senior U.S. judge, but he's actually carrying basically a full load here in our U.S. District Court. And Judge Woodcock reacted with alacrity. So as the general said, the case was filed on the 7th of April. On the 8th of April, Judge Woodcock called all the parties together in a conference call and said, with respect to this TRO request, and set a very quick time schedule for addressing the state's request that TRO be entered, preventing the cutoff of the school lunch funds. And Judge Woodcock basically ordered that the government would have another day by the 9th of April to respond to the TRO request, and that the state could take another day to respond to the response, and he would decide it as rapidly as possible.
So the litigation part of this, the back and forth of briefs, total of 3 days?
Basically, yes, and that's very quick for lawyers, as you can imagine. But fortunately, in this day and age, thanks to technology, lawyers can operate very rapidly. And our lawyers for the state, the talented lawyers on the Attorney General's staff, are not 9-to-5ers. They turned to and did what they had to do to cleave to that time schedule.
So the state made the arguments that Aaron Fry just told us. They made the response from the federal government in their pleadings was what, in summary?
Well, they said basically that it's not that big a deal, and that is that the state's entitlement to win this case is not that clear, and that the irreparable injury is not as bad as the state said. They said the state could get funds from other sources to take care of the school lunches, and so that really the federal government's order should not be disturbed pending the litigation.
And by the way, the argument that the state could, we have $10-11 billion budget, the argument was, well, the state could dip into some other fund to pay for these school lunches in the meantime. That's really not so.
There are restrictions upon just reaching in one pocket and taking it out and putting it in another pocket. These things are appropriated for particular purposes, and it would be, I think, difficult, if not impossible, for the state to come up with the money rapidly enough to provide a continuous lunch program.
So request for temporary restraining order, response from the federal government, rebuttal from the Attorney General,
Yes, and
all in a matter of a few days. Then what happened from there?
well, the judge was not idle in the meantime. And as this material was being filed by the respective parties, I'm quite certain that the judge and his staff were looking very hard at the case, and they, because the judge came out with his decision on the TRO on the very next day after getting the state's reply. So the state's reply to the government was on the 11th, and on the 12th, Judge Woodcock filed his opinion.
His two-page decision?
No, in fact, Judge Woodcock filed a 70-page written opinion setting forth not only that granting the temporary restraining order to the state, but setting forth the reasons why he, as a judge, was finding that the order was legally justified.
Okay, and in summary, what were the reasons he gave that this order was justified?
Well, yes, the rule of law requires that judges not only decide cases, but that they make known their reasons for deciding the cases. And if they just said you or you, no one would know why they decided or how that related to the rule of law. So that in the best tradition of the rule of law, Judge Woodcock painstakingly explained the reasons why he was believed that the law required him to grant the temporary restraining order and order that the lunches be retained. And in that respect, if you read his 70-page opinion, it is a really a masterpiece of judicial statesmanship. Because judges are not only applying of the rule of law, they have to explain it in a way that the people will understand their explanation and will accept it as being the rule of law. And that is exactly what Judge Woodcock did. So that he, first of all, in his opinion, it's well worth reading, he first of all summarized the factual background. And as the general said, he made clear, he didn't pull any punches, he made clear where this came from, that this was the product of the confrontation of the president with Governor Mills at the governor's conference, and that he certainly all but said, but didn't quite say, that this was a retaliation, otherwise it's very hard to explain. Then he went through the lack of process, the fact that this had just been a letter out of the blue, that there is a extended administrative process for the adjustment of funds in this context. And then finally, he applied the criteria for a temporary restraining order. And as the general said, there are basically three criteria. The first one is that the judge, in determining whether or not to grant this temporary relief, has to make an analysis as to whether or not the party seeking it, in this case the state, has a high likelihood of success ultimately when the case is all over with. So that if somebody comes in with a wing and a prayer and asks the court to, pending the litigation, to adjust the status quo in his favor, that doesn't make any sense. But if the party who's very likely to prevail wants to seek temporary relief now, that's what he has to establish. And then he had the second criteria is there going to be irreparable harm that can't be repaired in the final judgment if the temporary restraining order is not granted. And in this particular case, the possibility that children would not get their lunches and therefore be unfed for any period of time, or that the funds would be expended that couldn't be recovered, that would be an irreparable harm in that sense, and so that even if the state won, there would be harm. And the third criteria, though, also mentioned by the general, is how does this relate to the public interest? If you look at the overall picture, the interests of the children, the state, and the federal government, what is the result that better fosters the public interest? And Judge Woodcock's opinion goes through each one of these criteria carefully, and as I indicated, makes the judgment that yes, the state is very likely to prevail in the merits. Second, that there would be different forms of irreparable harm if the temporary relief isn't granted. And finally, that the public interest overall favors maintaining the status quo as far as the lunches are concerned, and holding up the applicability of the order.
So Judge Woodcock saved school lunches for Maine kids, at least temporarily. Aaron, what happened next? What could have happened next, and what has happened next?
With the order that clearly laid out what the lay of the land was here, we engaged with the Department of Justice, the attorneys for the federal government, right, and we very quickly resolved the case. So we got them to agree that they would keep the money turned back on, because the temporary restraining order that was issued turned the money back on. So we got the USDA to agree that they would keep the money on, and this was sort of interesting. We got them to agree that they would follow the law if they were to try something like this again. And once we got that agreement, then on our side, we dismissed the case. And so this happened over the course of just a few weeks.
So if the federal government hadn't agreed to do that, this case would have dragged on in litigation for probably some months before it was finally resolved.
Potentially.
Right.
But I think the benefit, so yes, if we had not come to any sort of agreement as to how to resolve the case, it could have gone on. But I think, what Peter had described, we had a very well-written, clear order from the judge as to where he saw this case going. And I think at that time, it would be fair for me to interpret that when the DOJ looked at the status of their client, getting more and more orders that demonstrated that the federal government completely failed to follow the rule of law was not going to be in the federal government's interest. Let me add something else on this. So not only did we get this case shut down very quickly by getting the agreement that the USDA would follow the law and keep the funding turned back on, but I did have at least one of my colleagues from another state talk about how he used this order in talking with his governor to say, look, governor, you don't just have to agree with what the president is telling you you should do. You can stand up and insist that the administration follow the rule of law and be successful. And so there was a reverberation of what we did here in Maine that was at least influential to how some other states made decisions about how to pursue their legal interests.
Yeah. So the case won here. Melissa, let me come back to you. What happened to the issue which caused all this fuss in the first place, the transgender athlete issue?
It hasn't happened yet. I mean, it's an issue that's fraught. It's very difficult for schools caught between a state law that's clear and a Maine Human Rights Commission that is very aggressive about making sure that schools are following that, and a federal law that's in flux. And that flux is going to take a long time, because we're going to have to get through the trial court, and then we're going to have to get through an appellate process, and finally to the Supreme Court. That's still in progress. We don't know what's going to happen. And in the meantime, it's really hard for schools.
Peter, you got the last 30 seconds. What does this case teach us about the rule of law?
Well, I think this is a great example of how the rule of law can work and should work and does work. And that, in fact, here's a government agency that does something that appears to be out of line, that appears to be a retaliation, and that doesn't follow the procedures followed by law. And the party affected, the state of Maine, through its lawyer, raises that question by going to court, the agencies that we have to maintain the rule of law in us. And here a judge of that court evaluates the positions of the parties and issues magisterial opinion, laying out the rule of law, applying it to the case, and preserving the rule of law here in our country.
Thanks. It's been a great conversation. Thanks
you.
for the three of you for being here. That's all for our show tonight. I'm Roger Cates, host of Rescuing the Rule of Law and a member of the nonprofit group Maine Lawyers for the Rule of Law. I'd like to thank our guests, Aaron Fry, Attorney General of the state of Maine, Melissa Huey, Civil Litigation Attorney in Portland, and Peter Murray, lawyer, law professor, and member of the Board of Directors for the Maine Lawyers for the Rule of Law. Thank you for joining us tonight. And if you'd like to donate to our efforts, You can find us at mainruleoflaw.org. Good night.